Goeiemorgen. People, I'm talking to you. I said Sabonan, you keep quiet. I said Goeiemorgen, you can't respond. Good morning, good people. Thank you very much. Thank you very much, Program Director, for this opportunity afforded to me. As I was introduced, my name is Ndou. I'm from the National Department for Forestry, Fisheries and Environment, based in Pretoria. I'm responsible for the enforcement of the alien invasive species regulation throughout the whole country. I'm referring to South Africa, by the way. So I will be presenting about the enforcement of National Environmental Management Biodiversity Act, Act number 10 of 2004, as well as the Alien Invasive Species Regulation, which firstly came into effect on the 1st of October 2014. But you have heard my colleague, she has spoken about the amendments that was done in 2020. So in my presentation, you can see I'm going to give a definition about what is enforcement. I will also give a legislative background. Where does the environmental right emanate or originate? And I will also give a background on the enforcement of alien invasive to say who's doing this enforcement of this alien invasive species regulation. What are the functions of the EMIs and who are the EMIs? I will also reflect on the monitoring, control, and eradication plan. I'm not going to dwell much on that because my colleague Cherise, she's done a wonderful job. I will also touch a little bit on offenses. When do we say somebody has committed an offense? What is an offense in terms of the Biodiversity Act as well as the Alien Invasive Species Regulation? What are the enforcement tools that the department, I'm referring to the Department of Forestry, Fisheries and Environment, what are the tools that they are currently using to ensure compliance? And what are the penalties as far as the Biodiversity Act is concerned? And then I will also reflect on 3 cases that have been finalized here in KZN, just to show that what are the implications that if you are not complying, I don't have any intention at all to intimidate anyone or to threaten anyone. I will be just trying to share with you what has happened and then what are the legal implications if you don't comply. And then after I will conclude. Enforcement, what do we mean by enforcement? So I try to research a little bit about this enforcement. Enforcement is a process of ensuring compliance with the provision of the legislation. In this context, we're talking about National Environment Management Biodiversity Act, as well as the Alien Invasive Species Regulation. So in this process, it entails taking action against the offender or the transgressor, referring to the person who is not complying. So the action taken may be administrative or criminal. I will explain in detail what do I mean by criminal and what do I mean by administrative. Legislative background. Where does the environmental right emanate? It has to start with our Constitution, the Constitution of the Republic of South Africa, Chapter 2, the Bill of Rights, in particular Section 24. It clearly states that everyone has got the right to an environment that is not harmful to their health and well-being, to have the environment protected for the benefit of present and future generations, through reasonable legislation that promote conservation and prevent ecological degradation. So you can see, everything is contained in our own constitution. It's not something that we just wake up and say, you know what, we want to disturb people. It's there in the constitution. Go and familiarize yourself with Section 24 of the Constitution. So Section 24 of the Constitution, it gives birth to National Environmental Management Act, Act 107 of 1998. We consider it as the principle of all environmental legislation because we say it's the principle, it's more like it's a bigger, it's the is the headline. Okay, from the National Environmental Management legislation, there were quite a number of legislation that were also published and come into effect, like the Waste Act, like the Air Quality Act, the National Environmental Biodiversity Act, but for this session I'm going to focus too much on the Biodiversity Act. From now moving forward, I will refer it as NEMA. Under NEMA, again, there were quite a number of regulations that have been published. For example, we have got the TOPS, Threatened or Protected Species Regulations. We do have the CITES. We also have the Bioprospecting Access and Benefit Sharing Regulations. And also Alien Invasive Species Regulation. So as I indicated at the beginning, we're going to focus on the Alien Invasive Species Regulation, which basically came into effect on the 1st of October 2014. I think this slide I already explained is all about what is enforcement. Then, you may be asking yourself, who is doing this enforcement of Alien Invasive Species Regulation? So the provisions of NEMA as well as the Alien Invasive Species Regulation, they are enforced by the environmental inspectors, commonly known as green scorpion. I can probably say that I'm one of the green scorpion. As you can also see the uniform. So this green scorpion, the EMI is a network of environmental enforcement officials from various spheres of government. So we do have environmental management inspectors from various spheres of government, like national, provincial, as well as the local authority. But for your information, the environmental management inspectors who are doing the enforcement of Alien Invasive Species Regulation at this stage, they are only based at the National Department of Forestry, Fisheries and the Environment. The EMIs work very closely with South African Police Service in investigating environmental crimes. What are the functions of the EMI? What does the EMI do? They monitor and enforce compliance with the provision of the law, like NEMA, as well as Alien Invasive Species Regulation. As Cherise indicated, she would go out and monitor compliance. She's not there to fight with anyone, she's just there to determine compliance. So it is also the responsibility of the EMIs to act, to investigate and act or omission where there is reasonable suspicion that an offense has been committed. So the EMIs will come and investigate the matter. If there is a complaint or there is reasonable suspicion that an offense has been committed. In this context, we're referring if there is a complaint that a landowner is conducting research activities without a permit. Example of listed invasive species, I just put this slide because I just assume that some of you might have not seen this alien invasive species, of which may be right or wrong, but I just felt that maybe let's share this slide so that we can demonstrate what are we talking about here.
This audience will know. This audience has seen them.
Thank you for that, okay. Yeah, as you can see, the first one is green iguana, the iguana, which is category 2. You have got Solanum martinium, which is a barkweed. You have got the wrongleaf parakeet, the ringnecks there. You have got Opuntia microdiasis, which is a teddy bear cactus. And I'm sure you all know by now, Lantana camara. And the last one is Acacia maize, the blackwater. So the EMIS does have the investigation powers. In terms of Section 31H, subsection 5 of NEMA, which is the National Environmental Management Act, the EMIS must be regarded as a peace officer or a non-commissioned police officer to comply with his or her mandate in terms of Section 31T. In other words, it simply means that the EMIS does have the same powers as the peace officers. It simply means that they do have the powers to can arrest, the power to seize anything which have been used in the commission of crime. They do have the power to search. But it's not only EMI who does have the power. The EMIs have been graded from grade 1 up to grade 5. So grade 1, 2, and 5, they do have the same powers as the peace officers. They can arrest, they can seize, they can search. So those powers, as I've indicated, they are in the same level as the police officers. Okay. Remember, the police officers, they get power from the Criminal Procedure Act, Act number 51 of 1977. So our EMIs, they also have the same powers as the police officers. So I just want to urge everyone here to work together with our EMIs. I mean, they're not there to provoke you, they're just doing their wonderful job. So let's work together. Invasive species monitoring, control, and eradication plan. I mean, my colleague Sharitz has spoken very loudly about it. I'm not going to dwell much on this one, but in terms of section 76, subsection 2, which read with section 10 of the alien, regulation 10 of the alien invasive species regulation. In short, it simply that all organs of the state, in all spheres of government, must prepare invasive species monitoring, control, and eradication plan. So if you read in law, if the law says must, it becomes very mandatory, very compulsory. So it's very important that all organs of the state which are represented here, they must go back to their organization and come up with this monitoring, control, and eradication plan. The Act further said this monitoring, alien invasive species monitoring, control, and eradication plan, they must form part of the IDPs. So if it's a municipality, they are legally required to include this monitoring, control, and eradication plan into their IDPs so that they can plan better. Let's just assume now they have to come up with this eradication plan, but it never formed part of the IDP. It will always be difficult now to come up with a plan because they've never even budgeted for that. So that's why we're saying when you do the budgeting, they need to consider that. Enforcement tools. I'm sure people may be asking here, what happens now if one does not comply? So currently the department is doing enforcement in 2 ways. Firstly by doing what we call administrative enforcement. Administrative enforcement simply means the issuance of administrative notices or warning letters. So depending on the seriousness of the matter, one will be issued with a warning letter if it's a minor offense. Let's say somebody is just having 2, 3 trees. We must just warn the person, and if the person comes into compliance, then the matter will be closed. In terms of section 31L of NEMA, we can also issue what we call a compliance notice. If there is a reasonable suspicion that an offense has been committed, we can issue that compliance notice. Alien Invasive Species Regulation 15 provides that a directive in terms of section 69(2) and section 73(3) of the NEMA, a directive may be issued. So these are the empowering provisions from the Biodiversity Act. If one is not complying, we can issue a compliance notice. We can also issue a directive. And these are legal binding documents, meaning that if one does not comply with a directive or a compliance notice, it becomes an offense, meaning that a case docket may be opened with South African Police Service. I explained at the beginning that we work together with South African Police Service. However, it is important for me to say that before we issue this final compliance notice and final directive, we issue what we call notice of intention. to issue a compliance notice or a directive. And a landowner will be afforded an opportunity to submit written representation as to why a final directive should not be issued. So you can see the EMIs are very reasonable people. They can't just wake up and start issuing with a final directive. They will firstly give you what is a notice of intention to issue a compliance, and then you will be afforded time to respond back to the department to say why the final directive should not be issued. And you may be asking why the whole process. Remember, we're in a democratic country. If you read section 33 of the Constitution, it states that whenever you want to take administrative action, that action must be lawful, reasonable, and procedural fair. So it can't be fair if now you just wake up and issue a directive. So you need to afford that person an opportunity first and then look at the reason. If the reasons are sufficient enough and the person comes into compliance, there is no need to issue the directive. Okay. But once now it comes to a stage of a directive, that's when now things get tough now. So you must read section 33 together with the provisions of Administrative Justice Act. In short, we call it PAJA. It also supports that whenever you want to take administrative action, that action must be lawful, reasonable, and procedurally fair. So if we afford you the opportunity, make use of the opportunity. Because some other landlords will just say, no, I don't want anything from this department. And in the absence of this written representation, we'll proceed with the matter without considering your reasons. And that's why now things it get tough, because no one wants to be arrested, no one wants to go to court. And I don't think that is not the intention for this regulation now to be taking people to court. But I mean, if people are not coming into compliance, unfortunately we're left with no option. We just have to do what the Act is saying. As I've said, if you fail to comply with a directive or it moves down to criminal enforcement. Criminal, it simply means that we're going to open a case docket against whoever is not complying. The case docket gets registered with the SAPS, and then finally it will be taken to National Prosecuting Authority for decision. Remember, it's the only institution which can decide whether to prosecute or not to prosecute. If they prosecute, the matter will go to court. Of course, there will be a trial. It will obviously start with a pre-trial, whether you're pleading guilty or not. You're pleading guilty, and then now the trial will start, and then magistrate will take the process, and the prosecutor will take the process forward. So this process is very straining, because now going to court, you have to get a lawyer want to be paid. It becomes very tough, this process. So, and that's what that is not what we want to achieve. We're saying let's work together. Let's fight against alien invasive species together, not us fighting against each other. But I mean, if people now they don't want to come into compliance, unfortunately we don't have any other road. Remember, no one is above the law. All of us we are equal before the law. Offenses, when we see somebody has committed an offense, in terms of section 101 of NEMO, it states that a person is guilty of an offense if that person contravened or failed to comply with the provision of section 65 or section 71 of section 1. What does section 65 say? It says that no person may carry an activity involving the disbursement of alien species without a payment. So, if you're going to be conducting these activities without a payment, and then you will be committing an offense. The same applies to section 71. If you are conducting these activities involving the disbursement of listed invasive species, one may be committing an offense. And I'm happy that my colleague Asibe has been talking very loudly about the permit, particularly for category 2 listed universities. So if you are a nursery and then now you want to sell and trade category 2 listed universities without a permit, for obvious reasons you will be committing an offense. Contravenes or failure to comply with directive issued in terms of section 692 and section 73. I think I've explained that if now the directive is out and the instructions are legal binding and then you don't want to come into compliance, it becomes a criminal offense, meaning that we have to open a case normally. Contrary or fail with the provision of section 69, 1 and section 73, 1. If you are issued with permit, you are legally required to comply with the conditions of the permit. Because that permit is not just issued for the sake of issued. One needs to comply with those conditions. And if you fail to comply with those conditions, one will be committing an offense. If you fraudulently alter any permit or make a false statement for the purpose of obtaining a permit, it's an offense. If you forge any document for the purpose of obtaining a permit, for passing it as a permit, it's an offense. If you conduct listed activities, in particular category 2, involving category 2 listed universities, you're going to be an offense if you don't have a permit. What are the penalties? These are the penalties in terms of the Act. It's not something that I'm just sucking now. It's written there in the Act. You can read for yourself. I'm referring to Binders Act. Section 102 of NEMA, it states that a person convicted of an offense is liable to a fine not exceeding 10 years, or to imprisonment for a period not exceeding 10 years, or to both such a fine or such imprisonment. Okay. So the maximum amount that an offender will be fined, it can amount to 10 years. You can see it's a lot of money. I don't know if they will give money to pay for this. You must read section 102 with regulation 36.2. I'm referring to earlier universities regulation. A person who contravenes or fails to comply with the provisions of the regulations, I specify the regulations there, is guilty of an offense and is liable to a fine not exceeding 5 million on first conviction, 10 million on second conviction, imprisonment for a period not exceeding 10 years. Now I'm going to reflect quickly on criminal cases that have been finalized here in KwaZulu-Natal. And I must say upfront that I don't have any intention at all to intimidate anyone. All what I'm doing, I'm trying to encourage landowners to comply with the provisions of the Acts or the regulations which are already there in place.
There was a case, it was State versus the owner of Noah Art Pet Shop. It was happening in Pietermaritzburg. The pet shop owner was selling or was in possession of the ring-rose parakeet, which is category 2 listed invasive species. In other words, he was selling or trading without a permit. He was issued with a pre-compliance notices. He was afforded the opportunity to submit written representation as to why he's not compliant. It didn't come into compliance. Final compliance notice was issued with instructions. He then applied for a permit. And then it was like the matter can be closed. So the EMIs went back and do a second inspection.
Unfortunately, now when they were doing the second inspection, they found new species by the name of common boa snake, which is also category 2, listed invasive species. Criminal case was initiated, get registered with the SAPS, sent to NPA for decision, and then they said they will prosecute. So in that case, the owner was found guilty. He was fined 50,000. He was instructed to pay 50,000, 20,000 immediately, and then 30,000 was suspended on condition that he doesn't commit the same offense within a period of 3 years. So it was happening here in this province. Second case, it was State versus Green Price. There was a complaint, inspection was done, information pack was sent to the landowner. 2 follow-up inspection was conducted, nothing was found. But on the 3rd inspection, the EMIs found that the pet shop owner was now selling or trading with Bemis pulver, which is also category 2, listed invasive species. Fortunately, in this case, the owner pleaded guilty. A fine of 20,000 was imposed. He was instructed to pay 10,000. And then 10,000 was suspended on condition that he doesn't commit the same offense within a period of 5 years. It was also here in KZN. Third case, it was State versus Granada Home Builders. A complaint was received by the department, inspection was done. During the inspection, a number of listed invasive species were identified. As far as I remember, they had Chromolina odorata, the paraffin wheat, those who knows them. They had Melia azaradata, the syringa. They had the bulk wheat. They had Arundodonus, the giant wheat. So it was just a jungle of listed invasive species. As I've indicated, pre-directive was issued. The landowner never took it serious. He even didn't use the opportunity that was afforded to submit written representation. Final directive was issued. Still, he never took it serious. Nothing was done on his land. A criminal case was initiated. Investigation was done only at the time when now the investigating officer wanted to obtain his warning statement. That was the only time that the landowner then realized that this thing is like it's getting serious now. So all what he did, he went back to the property and he cleared the property of this listed invasive species. As far as I remember, I think he spent almost 350,000 in clearing that property. On our side, we didn't drop the case. We proceeded with the case. He pleaded guilty. He was fined 50,000 or 2 years imprisonment. But it was suspended for 5 years on condition that he doesn't commit the same offense. So in this instance, the court considered the fact that he has already spent a lot of money, 365, which is a lot of money. So that's why we're saying, come up with this control plan. Look at your budget and see how best can we fight this alien invasive species. But you see now, you're going to be appointing lawyers. Now you need specialists to assist you. This exercise, I'm saying this because I know the thing is not a good exercise. But yeah, anyway, if People, they don't want to comply, there is nothing that we can do. In my conclusion, I just want to say, alien invasive species does not respect boundaries. So as landowners, we just have to work together. We have to work in unison. Whether it's a government department, whether it's a private landowner, we're saying let's work together against the fight against these alien invasive species. My last statement is to say, as you can see, this is morning glory. You can see this species is very gorgeous. Very beautiful species. Anyone will admire to have it in his or her own yard. But let me just caution you that these alien invasive species, they do have equitable impact on our environment. And if you really care about our environment, let's fight these alien invasive species. Program Director, thank you.
I'm sure from the floor we have some questions with regards to enforcement and the process that was discussed now. I know, just for interesting, the Green Scorpions recently arrested, and there was prosecution in Port Elizabeth for the illegal exportation of succulents which were removed from the wild, which was a good win in my view.
Question from Sandy.
Right.
Thanks, Futi from Sandy. I'm not sure if my question is for you. Between you and Cherise, so when we often refer to organs of state, we always target municipalities. I would like to know if the department has started engaging people with education. They own thousands of properties in the country. Health, police, transport, ESCOM, Transnet. Are we making any progress in starting to target those other organs of state, or is the focus now just on municipalities? Thanks.
Would you like to answer, Bernard? We never thought about schools before. That's the first time schools have ever come up. Yeah, really.
Thank you very much for such a good question. As I've indicated, all organs of the state, not only municipalities. So all organs of the state, maybe it's a government, any government department, maybe Department of Waters, and I'm just giving you an example, Public Works, Department of Forestry, Fisheries and Environment, if they own properties, according to this regulation, they have to submit the control plan. So to answer your question, we are not targeting anyone. So we have even already issued notices to other government departments who are not complying. So I'm just trying to demonstrate that the focus is not only on the municipality, but anyway, we encourage the municipality to come to the party. I don't know if I've answered the question.
It's fine, I'll let you go.
No. How many municipalities are you dealing with?
You don't have to name them.
I'm not going to disclose the names here, but I must say that if you think of some of the biggest municipalities in these countries, maybe metro city or district, some of them have already received these notices that we're talking about. But the good thing, they're coming into compliance, so they're submitting these control plans. So yeah, but at the same time, I must say this. Colleagues, I'm sure you know about Chapter 3 of the Constitution, which talk about cooperative governance. And I'm going to quote Section 41, subsection 3, states that an organ of the state involved in a dispute must make every reasonable effort to resolve the dispute before you can refer the matter to court. In other words, our Constitution encourages that if there is a dispute between two organs of the state, we must try by all means to resolve the issues before we think of taking the issue to the court. And I think that's where it creates a situation like this unfairness, because now with private landowners, it doesn't say, the constitution doesn't say much about it. So that's why you might find that when you're dealing with organ of the state, the process may be slightly different when you're dealing with the private landlord. And I think it's because of the constitution. Because if now we go to court, we have to demonstrate that we have exhausted all other measures now to resolve the issues. Otherwise, the court will just refer the matter back to the organ of the state which are involved in that dispute. So we can't just issue pre-directive. Now we run to court. So that is what the constitution says. That is not what I'm saying. Because I just have to make it clear, because people will say, oh, this person now is advocating for organ of the state. I'm quoting what is written in the constitution. And in my view, I feel like that's where now there's a problem. It's like private landowners are not treated the same as organ of the state. Thank you.
A comment from Debbie?
Yeah, I just want to congratulate the biodiversity unit for doing the amazing job that they have been doing with the limited capacity they have. So that is a huge thumbs up from our side. Thank you very much for all the concerted efforts that the biodiversity unit have been putting in. Thanks.
Thank you, David. I'm encouraging.
We have a question.
Hi, my name is Makosi Mkwanazi. I'm coming from AIS, the Invasive Alien Species Program. I just wanted to ask, are there any cases where warning letters are issued to perpetrators in the absence of maybe giving them some sort of grace period? And if there is a grace period, how long is it? Thanks.
I didn't get the question.
Okay, the question was the warning letters that are given without a grace period. In other words, immediate reaction is required. Do I understand correctly? And if a grace period is given, what is that period? Can it differ? Is it static, or is it a case-by-case evaluation?
Yeah, I must say it differs from case to case. But I mean, when you give instruction will be contained in the warning letter. Okay. Let's say, that's what I'm saying, it will differ from case to case. But you just have to be reasonable when you're giving instruction. You can't just say, within 2 days, everything must be removed. So probably when you talk about reasonable, 7 days to 14 days, that's when now you can say you are reasonable. For example, when we issue this directive, landowners is afforded 10 working days to submit return representation. So something that we can just say, now we are very reasonable people who understand that sometimes you don't have funds, you have to get all the necessary equipment and herbicides. So time frames will be indicated on the letter.
But I think it's also important that this time just to reiterate that the process of compliance would have already taken place. And in that process of compliance, there would have already been a period allowed for the landowner to comply. So it's not as if you just go and say, here's the warning letter right on the end. It's a whole intricate process to allow everybody a reasonable period of time. Am I correct in saying that?
Very correct.
Do we have any more? Do we have a question before we break for tea?
Thank you. Paddy from Wester, Lower South Coast. The most obvious spread of aliens in our area is along the provincial roads. And I haven't seen much sign of a management plan that is effective. They have recently cleared the vegetation along the roads, leaving behind the aliens. So I think there's a real need for compliance and enforcement there. And I realise that this is an organ of government, there are issues of budget, but there are also issues of making sure that the workers they use actually know how to do their job.
Thank you. We take that as a comment. Do we have any more else? Warren? Great. Thank you. Then ladies, thank you, Bernard. Let's give Bernard a round of applause. Another easy champion in front of the budget.